How should police handle underage drinking calls at houses? My name is Anthony Bandiero, attorney and senior legal instructor, bringing you the Roadside Chat. I'm in Irving, Texas this week. Just did our very popular search and seizure instructor class. If you've been to that class, share your comments below if you liked it or not. And if you're interested in that class, we're going to start streaming these ones on live. So this was the first week that we actually had the online students got to see the whole class. We had multiple cameras, and it was a really, really cool experience. All right, let's get down to business. So this one's going to be a little longer. So if you don't want to watch the whole thing, don't watch the whole thing, right? But let's kind of go through this because this is a situation that does come up a lot. So just background, right? We get calls for a loud party, excessive noise, and or underage drinking at a residence. Police knock on the door, and various scenarios can happen. The person answers the door. Police see other juveniles drinking out of red Dixie cups, maybe even beer or beer bottles and White Claws, right? Now the question is, all right, what can we do, right? First of all, is this plain view? Okay, so plain view is a doctrine that says that if officers are lawfully present, then things that they see, hear, and smell can be used as probable cause, right? So this is plain view. So officers see people inside the home drinking, especially if it's a container that's for alcohol. That's plain view. What sometimes mixes cops up, though, is they think that plain view alone is the exception to get them into protected areas. Plain view, a person opening their door and seeing evidence in the house, that is the exception to get into the home. No. That's not how that works. You need another exception to get lawful access. So plain view is right to be, right to see. Check out our new t-shirt on bluetogold.com, by the way, on their shop. It's pretty funny. Plain view is right to be, right to see. Plain view seizure adds an additional element, which is lawful access. Do you have lawful access? If you see evidence on the street, or, let's say, right next to the person drops the evidence, whatever, that's plain view, and you pick it up, you have lawful access, no problem. Maybe they abandon it. But when it's in the home, you don't automatically have authority to enter that home. So you need another reason: exigency, destruction of evidence, medical issues, consent, warrant, and so forth. All right. So there's the first question. Now, what happens if the person admits that they consumed alcohol? What if they admit that they're underage? All this stuff, right? Now we have probable cause. But what if they are not coming out? What if they open the door, but they don't want to come out? Can we grab them out of the home and pull them out? Well, this, in my view, is an entry of the home, despite the fact that they opened the door. Opening the door to police in and of itself is not consent to be arrested. It's not exigency in and of itself. It's simply talking to a cop during a knock and talk. And when your hand, right, passes that threshold and tries to go on habeas corpus on people and pull them out, that is known as body snatching, right? And if you are going to body snatch people out of their home, you need a recognized exception, right? You need some kind of exigency because of medical, safety, and so forth, right? So what I'm going to teach you is to use good judgment. Most people that watch my channel have drank alcohol as juveniles. And we call you a cop today. We call you an attorney. So you survived it. I survived it. And maybe sometimes you drank so much that there was exigency, but probably most of the time you weren't so blackout drunk that you were on the tipping point of a medical emergency. So I can tell you what I would do. If I saw people in a home, kids, and all I have is underage drinking, I would try to sweet talk them for their cooperation. I would seek their consent. Hey, look, guys, we know what's going on here. We don't want to make it more difficult than it is. Maybe some parents here. We're not looking to, jam people up. But we understand, sometimes kids drink, but you have no parents here. Try to seek their consent. But if you're going to go in anyway, then articulate some kind of exigency. Now, one thing could be the loud music, right? I do have some cases that talk about how the loud party can be the ongoing nuisance. But the reality is that most of these kids are going to turn down the music when you knock on the door, right? They're going to be quiet as a mouse when you knock on the door. So that ongoing nuisance will probably be alleviated by that time. The other thing that you may want to look at is, are these kids or is somebody in the home so young that it's, basically like an urgent manner to get them kind of in safe custody, right? So, preteens, obviously drinking is pretty extreme. But when you have kids that are, the high teens, right? 16, 17, 18, whatever it is, just consider what you have there. Do you have any, is anybody passed out on the ground? Can that person need medical attention, right? You don't know if they're passed out or they need, right, medical attention. So if we go into the home, can we now do a protective sweep to find out if other people are in the home that could pose a danger and so forth? I think the answer is probably yes. If you're lawfully in the home and there's all these kids and, they've been drinking and they're all trying to hide in the bedroom, I think it's reasonable to try to, get them into the living room, be able to have eyes on them. Otherwise, they could keep on drinking. Again, there could be some medical issues with these kids for alcohol poisoning. So I'm not seeing too many problems doing the protective sweep if you're already in the home, right? So I guess at the end of the day, you know how I work. I'm all about making good case law. I'm not about you riding the edge. I guess I could just be the 30-second video and say, you guys, maybe it's not clearly established. Go ahead and do it. Go make case law. But the problem is, whose name is on that case? Is it my name or is it your name? Am I going to pay any money or are you going to pay money, right? If you get it wrong, I'm not paying money, right? I'm just a guy on YouTube sharing my viewpoints. So it's going to be you. So if you're going to do it and you're going to put your name on it, let's make good case law. But here's the message of the video. At the end of the day, my message is this. If all you have and nothing more is a juvenile swigging out of a Coors Light can, I wouldn't enter. I would go seek a warrant. I would try to earn their cooperation. I would try to get a parent on the line to let me in, right? Get their consent. Their consent can override the other person. That's what I would do. But if I have any kind of medical issues, any kind of fighting, ongoing nuisances, people passed out, super young, young kids that are drinking and they need protection right now, something a little bit more urgent, then, I might go into the home. But at the end of the day, you do you. It's your case, right? Talk to your agency. What do they want you to do? I told you what I would do. Your agency is the final arbiter of what your decisions are going to be, and your lawyers, right? Your city attorneys, county prosecutors, and so forth. All right? Hey, am I moving this discussion forward at least? Am I giving you something to think about? Right? If I am, do me a favor, all right? Like, subscribe, share with your friends, comment below, disagree, agree, any kind of feedback. It helps me too to see what you guys are doing out there. All right? All right.